Any mention?
May I please, Your Lordship? Your Lordship, I beg to mention item number 14, Your Lordship. I pray this matter may come up after 2 weeks, Your Lordship.
Who is the other side?
We are for the other side, Lordship. We have no objection, Lordship. No objection.
This is a criminal appeal.
Yes, Your Lordship.
Item 13, 1-3.
14, Your Lordship.
14.
1-4. Request. When do you want it?
After 2 weeks, Your Lordship.
2 weeks of the request for the petition. Yes.
Much.
Lordship, I beg to mention item number 11 and 12. The conducting counsel B Pathak has some personal difficulty.
No objection, Lordship.
When do you want it?
Lordship, after 3 weeks.
Is it all? 11, 12. The request made on Mr. B. Pathak, learning counsel for the petitioner. List is matter after 3 weeks. Yes.
Deeply obliged, Lordship.
Please, Lordship. Lordship, I beg to mention a matter for motion today unlisted. As a criminal petition, Lordship, the urgency is that it emanates from a GR case in Mokirwat under section 417, where Lordship, on 2 occasions the defense counsel there filed an adjournment for certain reasons. Now the matter, without giving any opportunity of final hearing to the accused, has proceeded for judgment. It is fixed day after tomorrow, Lordship.
For judgment.
For judgment without any...
If judgment is fixed for judgment, what can we do?
So, Lordship,
Can you stop the pronouncement judgment?
we are saying that we need
Can
an
you pass an
opportunity.
interim order asking the court not to pronounce judgment?
Lordship, my basic prayer in the petition is to allow us an opportunity of filing.
Tomorrow,
hearing, Lordship.
just tomorrow, not today.
Obliged.
May please, Lordship. Lordship, I beg to mention item number 10, Lordship.
Yes.
Lordship, this matter can be taken up after a week.
No objection.
You are for the
Petitioner.
Autonomous District Council. You are the District Council.
Yes.
Item, you are mentioning item 10.
Yes, Lordship.
JHDC is the petitioner, yeah?
Yes, Lordship.
And what is the matter about?
Lordship, this is regarding setting up check gates, Lordship.
This issue, is it pending before DV, you know?
Lordship, that's what we, as per couple of orders which this Honorable Court has recorded, Lordship, the matter is pending before division bench, Lordship. But then the petitioners in this case are saying that matter is different.
Just Mr. Karwan, Leonard G. appearing for the state respondent. Despite for adjournment of the matter by when? When do you want it?
Lordship, after 1 week.
After 1 week. Here, after 1 week, it will be taken up. Yes. All right. Clear. Adjournment of the matter by 1 week. Good. So, Learning Council appearing for the petition has no objection. Clear alert. List after a week. Yes.
Lordship.
May it please, Lordship. Lordship, I beg to make a mention of item number 1, Lordship.
Item?
1, Lordship.
Yes.
Lordship, I'm praying this matter may be listed after.
2015 matter. No adjournment.
Lordship, we need some time to
Enough time was given to you. See.
just
have this
another 2 weeks, Lordship.
No, why do you want 2 weeks? Right?
We need some time, Lordship, to
See,
prepare.
this matter is pending unnecessarily.
Lordship, just another 2 weeks, Lordship.
Yes. Who is the respondent?
Lordship,
What do you say?
no objections, Lordship.
No objection. So you are happy to keep this matter pending?
So weeks
Lordship,
time.
have after a week.
When do you want it?
2 weeks, Lordship.
Yes, sir. Yes, sir. Petitioner. Learning Council, appearing for so and so, please for adjournment of the matter by 2 weeks. The council appearing for the respondents has no objection. Prayer allowed. List after 2 weeks. Yes.
Lordship, similar prayer for item number 6, Lordship.
Item number?
6. Six.
Who is the other side here? No objection. No objection. Same order. Yes.
Lordship, similar prayer for item number 7 and 8. Lordship, connected matters. Lordship.
These are connected.
Lordships.
Who is for the state here?
Yes,
Yeah,
sir,
for the
lordship,
state.
yes, dear lords.
Yes. Same. Yes.
My son.
Obliged.
Lordship, similar prayer for item number 9.
You said.
No objections.
No objection, Your Lordship.
Yes.
Highly obliged.
May I please, Your Lordship?
Yes.
I beg to mention item number 3, Your Lordship.
Please, Lordship.
Yes.
Your Lordship, let the matter come after 2 weeks, Your Lordship.
This is Akang matter, right, for the private respondent. They see from the go from the record. You can find the lordship. They have been continuously
Your
asking
Lordship, the
time
conducting counsel
from the
is
time.
still under treatment, Your Lordship.
Yes, lordship conducting session the council last time he is having leg problem, but yesterday he has come to the court. Now he is making a
He is
submission
still
there.
not okay, Your Lordship.
He was okay because from 2017, of course, we understand some difficulties, but then every time when the matter comes, something or other way they have to take it. We
What
are,
is to be done?
lordship,
If
because,
any adjournment is sought on the ground of illness of the council, then what shall we do?
lordship, but my submission is, of course, we understand their
you see,
difficulties,
we-
but then randomly they have been keep on asking time every time. One or two occasions, if we are really sick, then we understand. We also consider. We feel, of course, that is okay. But then,
Learned counsel, okay. Learned counsel. Appearing on behalf of Mr. H. Hajarika, learned counsel for the petitioner. Sought grant of, sought adjournment of the matter. On the ground of illness, be conducting counsel. Mr. Petition, learned counsel looking for the respondent has objected to the prayer. Step. Paragraph, however, for the interest of justice, however, taking into consideration the ground of adjournment and for acts of justice, prayer for adjournment is list of 2 weeks.
Highly obliged.
much less lordship.
Your Lordship, I beg to mention item number 2, Your Lordship.
Yes.
Item number 2, Your Lordship. Your Lordship, let this matter may come up after 2 weeks, Your Lordship.
Why?
As the conducting counsel is not well, Your
Who
Lordship.
is the conducting counsel?
S. Day, Your Lordship. S. Day.
He is not well.
No, Your Lordship.
We have no objection, Lordship.
The request made by learned counsel for the respondent. Not objected to by the learned counsel of the petition. List this matter after 2 weeks. Yes.
Your Lordship, similar prayer for item number 4, Your Lordship.
Item 4 has not been mentioned. Was it mentioned, item 4?
No,
It
Your
was not
Lordship.
mentioned. Who is the petitioner here?
Lordship, my apology, Lordship.
Yes, you are ready to do it.
Lordship, private respondent has to come with instruction, Your Lordship, in this matter. The private respondent has to come with instruction in this matter, Your Lordship.
So you are making a mention on behalf of whom?
On behalf of respondent number 1, 2, 3, Your Lordship.
Who is the private
District
respondent?
Council. Sir.
What instruction is required here? What?
In fact, the matter was argued, and I have conceded that the matter can be remanded back to the chief executive member. Because what has happened here, Your Lordship,
And then what? Oh no, it is pending for what today? What instruction is required to be taken?
Lordship, on the last, spare the last order, Your Lordship. They have to come instruction whether to proceed the matter here or to contest in the election, Your Lordship, or to remand back the matter.
Many such thing required.
So what has happened here is a subsequent development, Mr. Lordship. The private respondent, who is functioning as a Bobura, there's a fresh complaint against him, and he's been suspended. And we have filed a fresh petition whereby this Honorable Court has granted.
So you are continuing in the
I'm
office.
still continuing.
So that way there is no difficulty for you to appear on behalf of the private respondent. You are still the headman.
Your Lordship.
Anyway, what is to be done?
Let it be after 2 weeks, Your Lordship.
No objection. Same order. Request being so and so. Not objected to by the Land Council petition and list of the weeks. Yes.
Highly obliged, Your Lordship. May I please, Your Lordship? I beg to mention item number.
Remaining, anything remains in the list?
Oh, I don't know.
Yes.
I beg to mention item number 5, my lord.
Item 5.
Yes, my lord.
Yes.
My lord, the counsel for the respondent is under the weather, my lord. So I'm seeking some time.
Same order. When do you want it?
After 2 weeks, my lord.
Just write it like this. Yes.
It's a old matter.
Yes, but then if you are not willing to do what the
No,
court
no,
can.
no. Because he informed me he's unwell. H.N. informed me he's unwell. May crave
do not
your
have
lordship, I think many matters since adjourned, so items 17 and 18 can be upgraded if lordship, no inconvenience caused, I think.
Let us see what is there. Why should we
As
disturb
you-
the list? This is hardly any matter.
Yes, as you wish.
Item number 13.
Yes. You are for the respondent.
Respondent,
Who is for the appellant?
Mr. Sheikh,
He's not there.
it's not there.
None appears for the appellant. Mr. Hind, Leonard G. is present on behalf of the state respondent. This is met after 2 weeks. Yes. After 2 weeks? That is all right. 2 weeks.
Item number 15.
May it please, Your Lordship.
Yes.
My Lords, it's an application under section 482 for quashing of the case, my Lord. If Your Lordships would kindly come to the FIR, which Your Lordships will get at page number 139.
Who is there for other side? Yes. Is there?
The Director of Meghalaya State Lottery Shillong, entrusted with the functioning of promoting, organizing, conducting and to do all other allied works relating to lotteries in accordance with the relevant
We are reading
provisions.
page 139.
139, Miller. Type copy. Milord will kindly have item number 18, Milord. Please, I'm sorry, Milord.
You are appearing in both the matters.
I'm appearing in item number 18, Milord. My friend is appearing in item number 17.
You note that, huh? Do not commit any mistakes. Yes.
The Director of Meghalaya State Lottery Shillong, entrusted with the function of promoting, organizing, conducting and to do all other allied works relating to lotteries in accordance with the relevant provisions of the Lotteries Regulation Act 1998, the Lotteries Regulation Rules 2010, and Meghalaya Lottery Regulation Rules 2019. The Government of Meghalaya has published a notice dated 28th of March 22 for inviting expression of interest from eligible parties for appointment of distributor for operation and marketing of paper and online lottery on behalf of Government of Meghalaya under the relevant provisions of the Lotteries Regulation Act and Meghalaya Lottery Regulation Rules 2019. Thereafter, one Messrs. So-and-so Network Private Limited Chennai has submitted his expression of interest dated 28/3/22. Upon careful consideration, the Government of Meghalaya, by letter dated 27/6/22, has accepted the expression of interest of the said Aspira Star Entertainment Network Private Limited, and by an agreement dated 16/9/22, one Messrs. Aspira Star Entertainment Network Private Limited Chennai has been appointed as distributor to conduct marketing and sale of all kinds of lottery schemes online and paper on behalf of the Government of Meghalaya under the relevant provisions of Meghalaya Lottery Regulation Rules 2019, etc. Further, the said distributor has formed a special purpose vehicle, that is Amdura Innovation Private Limited at Shillong. Apart from the above said distributor, one Messrs. Utchip Gaming Private Limited at Tejpur, Assam, has submitted his expression of interest dated 28/3/22, and upon careful consideration, the Government of Meghalaya, by letter dated 27/6/22, has accepted the expression of interest of Messrs. Utchip Gaming Private Limited. Thereafter, the Government of Meghalaya has entered into a distribution agreement dated 31/8/22 with Messrs. Utchip Gaming Private Limited to conduct marketing and sale of all kinds of lottery schemes online and paper on behalf of Government of Meghalaya under the relevant provisions of the Meghalaya Lottery Regulation Rules 2019, etc. Further, the said distributor has formed a special purpose vehicle, that is Messrs. Eastern Infotech Private Limited at Kolkata. The information regarding appointment of the distributor was also communicated to Director of the State Lotteries in various states. Subsequently, Government of Meghalaya, by communication dated 25/8/2023, has informed the distributor, that is Utchip and Eastern Infotech, at Kolkata that a lottery draw scheme, that is Singham weekly draw, has been formulated by the state government of Meghalaya for conducting lottery draws. The details of the draws under this scheme are as follows. Serial number 1, day Wednesday, draw name Singham, Wednesday weekly lottery. Day number 2, Thursday draw, name Singham, Thursday weekly lottery. Day number so and so and so forth. Then my lord will kindly come to paragraph 7. As per the terms and conditions of the distribution agreement and as per the relevant provisions, the first draw was held on 38/23 under the name Singham Wednesday Weekly Lottery, and thereafter the results with the winning tickets were also published. This being so, the office of the Directorate of Meghalaya State Lottery has reliably learnt that one Martin Santiago, that is the petitioner in item number 18, Managing Director of Messrs. Future Gaming Hotel Services Private Limited, having his registered office at so and so, and Nagarajan, who is the close associate of Martin Santiago, who is the petitioner in item number 17, conspiring together and indulging in illegal activities of criminally intimidating, threatening, coercioning, and causing undue influence on the stockist and substockist on others in order to destroy the competition, since the named persons are practicing monopoly in the field of lottery business. The criminal activity of the above persons caused loss to the exchequer of the state of government of Meghalaya. The persons referred to above have been unlawfully preventing the official distribution and business of the Meghalaya state lotteries continuously through various illegal means and criminality, thereafter threatening the stockist and others, and also by manipulating them with false and defamatory information to curtail the distribution of Meghalaya state lottery at Police Bazar, Shillong and other parts of Meghalaya and other states, that is West Bengal, Punjab, Maharashtra, etc. It is pertinent here to mention that the said Mr. Martin Santiago through their and his associate Mr. Subayan Nagarajan, henchmen and gangsters, gave continuous and serious threat to the stockist, substockist and others, and thereby prevented them from carrying out the business with the Meghalaya State Lottery. The said illegal activity carried out by Mr. Martin Santiago and his associate, Mr. Subayan Nagarajan, through their antisocial elements caused a huge business loss to the Meghalaya State Lottery, approximately to the tune of rupees 1500 crores, by indulging in criminal activities of threat, coercion, undue influence, criminal intimidation, etc. Said sum of 1500 crore is an approximate loss due to the Meghalaya State Lottery, and said amount was indirectly diverted to the income of the company owned by Martin Santiago and his associate, Mr. Subayan Nagarajan. That apart, this office of Meghalaya State Lottery also came to know that said Martin Santiago and Subayan Nagarajan, through their henchmen and rowdy elements, has been indulging in antisocial activities and eliminated several competitions by illegal means for the past several years, and has been accumulating several crores through illegal means. The persons referred to above have been strenuously spreading defamatory and false information in person and also through electronic mode against the lottery business of Meghalaya State Lottery, and also cause undue influence and coercion with the intent to apprehend the fear among the stockists and others, and thereby illegally gain undue advantage. The illegal activities led to fear and apprehension among the stockists and others, who in turn are illegally prevented from carrying out lottery business with the state of Meghalaya, and as such, the named persons who are instrumental in illegal activities against the Meghalaya State Lottery are liable to be prosecuted under section 406, 420, 425, 464, 499, 503, 506, etc. of the Indian Penal Code and Information Technology Act. Therefore, on the reasons stated in the foregoing paragraphs, it is humbly prayed that a case may be registered against accused number 1, Martin Santiago, so and so, and Nagarajan, who is the close associate of Martin Santiago, and conduct the investigation for the offences stated above, and may take appropriate action action. Yours faithfully, etc., etc. Say the director of state lottery, Srimati Mary Sonti and Marak was the informant. Now, my lord, what is most important to notice in the FIR is
The distributor did not file any FIR.
No.
They are threatened. In fact, the allegation is about
the
that.
stockists, the distributors. Because under the scheme of the Act of 1998, Maida, it is the actually on behalf of the state government, the distributor organizes the lottery. So distributors are not before anybody. Now, what is most important to notice in this case is, my lord, if your lordship would kindly come to page 35, 135. Now, please come to me, Lord, 3. Occurrence of offence. 28.3 from 28.3.22 to 28.3.22.
That is a single day.
Yes.
That means you are threatened once. You have threatened them once.
No, the issue is, my lord, the stockists came to be appointed only in the month of August and September. So on 28.3.22.
2022.
Yes. Kindly come to, that's why I was referring to this, my lord. If your lordship would kindly come to for a moment to page 141, my lord.
Just
The alleged occurrence is of 28th of March, whereas on that day there were no stockists.
Page
141, my lord. If your lordship would kindly come to para 7.
Yes.
As per the terms and condition of the distribution agreement and as per the relevant provisions, the first draw was held on 38/23 under the name Singham Wednesday Lottery, and thereafter results were so and so. So, and before that, my lord, if your lordship would kindly come to paragraph 6. Sorry, my lord. Sorry, my lord. 140, paragraph 4. Para 4 at 140. Upon careful consideration, the government of Meghalaya, by letter dated 27/6/22, has accepted the expression of interest of the said Aspirastar Entertainment Network Private Limited, and by an agreement dated 16/9/22, one Aspirator Entertainment Network has been appointed as distributor. So, and the first one was actually on 31/8 million at para 5, and second one was on 16/9/22. There were two distributors, one is Aspirator and other is Uchip. Para 5, Uchip was appointed on 31/8/22.
So both are after the date of occurrence.
Yes, Miller. So that means on the date of alleged occurrence, there were no distributor. Therefore, the allegation is inherently improbable. There is no occasion to, my lord, criminally intimidate anybody because there was none. My lord, these are all handiwork of the, my lord, competitors, my lord. They are just misusing the authority.
No, but then why authority should come to see if there is no complaint?
Yes.
By the distributor?
Precisely. I'm actually, Lordship has really found out the right point, my lord. If any stockist has been threatened, then they should file an FIR. Why director? So, my lord, now this is the aspect. Now, my lord, regarding this aspect of 1500 crore, my lord, if your lordship would kindly permit me to place 2 paragraphs from my pleadings, my lord, and if your lordship would kindly come to page number 24, my lord. Effectively, my lord, the FIR was registered on 11/9/23. So there were only 13 days when these, my lord, draws were held. Please come to page 24 of the petition, Roman 6. Uh, 38/23, my lord, was the first draw. Yes. At page 24.
Yes.
During 38/23 to 11/9/23, that is the date of the complaint, the number of schemes notified by the state of Meghalaya and total number of tickets along with total number of schemes is provided herein under below in a tabular form. My lord, from 3824 to 11/9/23, the span of 13 days, my lord, only total MRP value of the tickets involved is only about 67 crore 59 lakhs 18,880.
Yes.
Now, if your lordships will kindly come to page 25, Roman 7. From the above table, it is evident that total MRP value of tickets involved in the scheme between 38/23 and 11/9/23 was 67 crore 59 lakhs and odd. However, after payment of the prices and applicable GST on sale of lottery tickets, the amount left for distribution as profit between distribution network and the government of Meghalaya would be less than 25.8%. To be precise, a calculation of the said profit margin is provided herein below. Total number of tickets involved is 51,99,376. MRP of each ticket is rupees 10. So total value of ticket is 5 crore 10 lakhs 99,000 and odd. Price payout as per this scheme 50.so% of MRP. GST is 28%. Profit margin left for entire distribution network, assuming no other expenses are incurred, 100 minus D&E, so it comes to 27.so%. Profit margin for the government of Meghalaya 2%. Now, assuming that the government of Meghalaya earns 2% of the total profit margin left, still it could earn only 2% of 27.so, that is 0.5494%. Therefore, maximum loss that government of Meghalaya could have incurred during 30/2011 to 11/9/23 can only be 37,13,498. However, the FIR inaccurately cites a false and inflated figure of loss, attempting to fabricate an allegation where none exists. So, my lord, assuming if their allegation is correct, instead of 1500 crore, my lord, it will be only 37.30. Now, that notification by which they were appointed is at page 154, my lord. 154, my lord. That's the notification dated 23rd of August 23 by the government of Meghalaya. Governor of, has your lordship got it? I'm sorry.
Yes. Please.
Governor of Meghalaya is pleased hereby to make the holding of following draws of state lotteries, Meghalaya, Government of Meghalaya under Lottery Regulation Act, Lottery Regulation Rules, and Meghalaya Lottery Regulation Rules 2019, State Lottery Regulation Rule 2022, and subsequent amendments made thereto, and guidelines instructed issued by the central government and state government from time to time. This is in exercise of the power conferred by notification dated 10th of January 2020. Singham weekly draw, first draw will be held on 30th of August 23 as fixed by the director Meghalaya Lottery on a particular day in a week according to the name of draws except 3 national holidays. Number of this series 51,99,376 of tickets. If we multiply it by 10, the figure would be 5.19 crore. Then place of ticket, etc., etc. And at page 155, my lord, entire scheme is, detail given in detail. It is given, my lord. Clause 7 is regarding price and collection ratios. So eventually, my lord, assuming there was something wrong, then it is only to the tune of 37 lakhs. Not to the tune of 50 or 1500 crores. Now, my lord will kindly come to page number 135 again, my lord. Now, see, my lord, 11/9/23 was the date and time of the affair. at 1710 hours. Kindly see the sections. 406 criminal breach of trust. Who has entrusted whom? Who has
There's a delay of 1.5 years in lodging the FIR. Yes.
Then, my lord, 420 cheating, 426 mischief, 500. My lord, how can a criminal defamation be registered, my lord, based on an FIR or a complaint? FIR, my lord. Then 506, 120B 34. Now, my lord, date information received 11/9. So from 38/23 to 11/9, it comes to 23 days. That's the 13 days. Now, my lord, while making our original arguments, my lord, we relied upon section 157, subsection 1, proviso B, where we tried to submit for lordship's kind consideration was there are certain situations when investigating officer will not investigate a case. There we relied upon the decision of the Supreme Court in Bhajanlal. If your lordship would kindly have the Bhajanlal for a moment.
If this FIR was registered in the month of September 2023, when did you approach this court?
We approached your lordships.
24.
We approached
very late.
Yes.
We approached on 23rd November.
Yes.
That also more than a year after the filing of the FIR.
We came to know only then, my lord. Because it was everything was kept in under the carpet, my lord. And no, the issue is, my lord, in lottery business, my lord, even there is a order of division bench, order of this on Guwahati High Court, my lord, where this aspect of the matter was taken note of. Basically, my lord, under the scheme of the Lottery Regulation Act 1998, on behalf of the state government, basically it is the distributor who operates the, my lord, show. Now there is a great deal of rivalry, my lord. Now there is no doubt that the petitioner in item number 18, my lord, he is a very renowned in this line of business, my lord. Therefore, he has got a lot of enemies. Now they cannot compete. Now they try to harass people only through this method. Now there is one judgment of Guwahati High Court, my lord, where this aspect of the matter was taken note of. I'll just place that judgment before I go to the other aspect. No. If your lordship would kindly come to page 120, my lord. That judgment we have annexed.
The compilation which is submitted?
No, my lord. In the writ petition itself, in the quashing petition itself, yes, we have annexed that. Now, if your lordship would kindly come to paragraph number 17 at page number 120. Just to understand, my lord, how it operates.
Yes.
Page 120, it's a division bench judgment of the Guwahati High Court at para 17.
Yes.
The organization and sale of lottery ticket is a business in which the vying states are always in a competition to shuffle out the other rivals in order to garner maximum sales and thereby earn maximum profit to the coffer of their state. The provisions in clause 1 of rule 9 of the rules of 200 makes an unreasonable distinction between the state of Maharashtra and other states. Lord, the other observations are in the context of the case, but the first 3 lines I have referred to this to show, my lord, what was an aspect which was taken judicial notice of by the High Court, my lord, that to Guwahati High Court. Then, my lord, the reason is, if your lordship would kindly come to page 187, 110, para 87. while interpreting Section 5 of the Act of 1998, my lord, this is what Supreme Court said at para 87. We find on a plain reading of Section 5, it empowers the state government within its state to prohibit the sale of ticket of lotteries organized by every other state. There is also nothing in the language reading by itself as to say whether such power can be exercised by the state while running its own lottery or can be exercised only where such state does not run its own lottery. This leads to two possible interpretations as referred to above. In view of the settled principles of interpretation, the interpretation given by Union of India to read down the provision has substance. This should mean that state could only exercise such discretion if it decides not to have any lottery within its territory, including its own lottery. In this situation, the delegate is tied down by this limitation, which itself is a clear guide to a state, hence cannot be said to be unbridled delegation. So even to the first part, it cannot be said to be arbitrary or unbridled. So we have no hesitation to approve the interpretation given by Union of India to uphold the validity of Section 5. Lord, to give an example, my lord, supposing state of Meghalaya, if we want to ban lottery, then we'll have to ban our lottery.
Why you are venturing into those areas?
No, just to we are for lordship's kind consideration, my lord. This aspect of the matter has been brought into just to highlight the motive of filing this FIR by some vested interest who are our competitors, my lord. To emphasize first that it is a business where there are stiff competition and the competitors are always at ends to find out fault with others just to put them into trouble. That is the only purpose. So that is the purpose for which, my lord, we have referred to these judgments. Now, my lord, all that we are trying to say in this case is, it's a clear-cut case, my lord. Even if we take the allegations into face value, no case is made out, my lord. There is no case is made.
We'll have the hearing on that day. It seems like you were.
I'm sorry, my lord.
Kindly, this is.
I'm so sorry. I'm so sorry, my lord.
This is a problem.
No, I'm so sorry. Actually,
it's a senior counsel.
No, I'm so sorry. What had happened?
It is not that this is like this court should be taken for granted.
No, I'm so sorry. I'm extremely sorry, my lord.
This is the third time you see. This is.
I'm sorry, my lord. What had happened, my lord, I was trying to unlock it. I could not, my lord. In fact, I asked my junior to do.
You should have kept the machine outside.
Yes. I'm sorry. I'm extremely sorry.
It happens sometimes before we were sitting. I had noticed it. You are a senior counsel. This court has respect for you.
I do agree, my lord. I apologize. I apologize for it. I do apologize. I tender my apology for it. I'm so sorry. My intention was not to, cause any inconvenience to the honorable court, my lord. I apologize for it.
See, it is not a question of inconvenience.
I'm sorry.
A decorum,
it's correct. Absolutely.
Which should be maintained.
Yes.
Even the code is bound to do it.
Yes.
I'm not carrying my mobile with me.
No, absolutely. No, my lord. Actually, my mobile is off. The problem is this phone, my lord.
No. Because you want the Bluetooth.
Huh?
You want the Bluetooth. I am so wearing, but I don't. I off the Bluetooth. That's why it's not coming in my hand.
Okay. Anyway, I'm sorry. Yes. Now, if your lordship would kindly come to the substance of the matter. Now, if your lordship permits me, I will go section wise, my lord, to show that there is no, materials to or ingredients of those provisions are not there to constitute the offence. Therefore, it's a fit case where lordships would like to, my lord, pass the proceedings. First, for the purpose of that investigation part, my lord, I would like to rely upon that Bhajanlal's case, my lord. A compilation was given, my lord, the thicker compilation.
Yes, there was.
This one, my lord, the bigger one.
Is the compilation?
Yes, my lord.
6 decisions. This is the.
No, my lord, a slightly bigger one. This one. Now we have given everything in one, my lord. Yes.
No, but then these are the only thing which were given to us.
If your lordship would kindly have this, Miller.
Do we have the
Other side?
Do we have the copies?
You have given it. I have given.
These are the one.
My lord, if your lordship would kindly come to page number 44 of that compilation. Sorry. Please come to page number 27, my lord.
Page 27.
Yes, para 48.
No.
No, this is in the other day we have given you all the copies.
These are the only copies on it. Yes.
No, we have given you
No.
here.
The paging in your reference and the paging here is
Okay. I'll rely on the earlier compilation. Earlier compilation is Bhajanlal's copy we have given, no? Bhajanlal? Given.
No.
No, on the last occasion we have given.
It's not here at the table of contents.
Yeah, extra banabo disilo na banabo.
See, Mr. Chaudhary, I think
we have given a copy, Miller.
there should not be any disruption, you see.
I'm
See,
sorry.
if it
I'm sorry.
court gets distracted.
I'm sorry. I do understand, Miller.
And honestly, this court doesn't have very good temperament. That is also a problem.
It's okay, Miller. There is no problem. We are used to it, Miller. Sometimes it happens. We are all human beings, Miller. Sometimes we all falter. End of the day, Miller, we learn every day from mistakes.
That is a continuous process that will go on.
Yes. If your lordship should kindly come to page 27, Miller, please come to page number 361, para 48.
361. Where's the 360?
One should not, para 48, 361 of the judgment. This judgment.
Now you are not referring to Bhajanlal anymore.
Yes, Bhajanlal only, Miller.
361 of which?
No, Miller. 361 of the in the Supreme Court book, Miller. Here, page 27.
Very confusing, a lot.
So, you tell the number which you want the court to see.
I'll draw your lordship's kind attention to page 27 of the compilation. Only for my learned friend, I told him page 361. Miller.
So again, when he responds to that, then we will have difficulty again. Then he will refer to some page 33 something.
One should not lose sight of the fact that section 157(1) requires the police officer to have reasons to suspect only with regard to the commission of an offence, which he is empowered under section 156 to investigate, but not with regard to involvement of an accused in the crime. Therefore, the expression reasons to suspect the commission of an offence would mean the sagacity of rationally inferring the commission of a cognizable offence based on the specific articulate facts mentioned in the first information report as well as in the annexures, if any, enclosed, and any attending circumstances which may not amount to proof. In other words, the meaning of the expression reasons to suspect has to be governed and dictated by the facts and circumstances of each case, and at that stage the question of adequate proof of facts alleged in the first information report does not arise. In this connection, we would like to recall the observation of this court made in the state of Gujarat versus Mohanlal J. Parwal while interpreting the expression reasonable belief. It runs thus: whether or not the officer concerned had entertained reasonable belief under these circumstances is not a matter which can be placed under legal microscope with an overindulgent eye which sees no evil anywhere within the range of its eyesight. The circumstances have to be viewed from the experienced eye of the officer, who is well equipped to interpret the suspicious circumstance and to form a reasonable belief in the light of the aforesaid circumstances. Resultantly, the condition precedent to the commencement of investigation under section 157(1) of the code is the existence of the reasons to suspect the commission of a cognizable offence, which has to be prima facie disclosed by the allegation made in the first information report laid before the police officer under section 154(1). So before the investigation officer, my lord, decides to go ahead with the investigation, then he must have that satisfaction that there is a reasons to suspect. Now my lord will kindly come to paragraph number 5(1). As pointed out in the earlier part of the judgment, section 157(1) is qualified by a proviso which is in two parts, A and B. Clause A of the proviso is only an enabling provision with which we are not very much concerned. However, clause B of the said proviso imposes a fetter on a police officer directing him not to investigate a case. This is very important. I am just repeating that sentence. However, clause B of the said proviso imposes a fetter on a police officer.
Please go ahead.
However, clause B of the said proviso imposes a fetter on a police officer directing him not to investigate a case where it appears to him that there is no sufficient ground in entertaining an investigation. As clause B of the proviso permits the police officer to satisfy himself about sufficiency of the ground even before entering on an investigation, it postulates that police officer has to draw his satisfaction only on the materials which were placed before him at that stage, namely the first information together with the documents, if any, enclosed. In other words, police officer has to satisfy himself only on the allegations mentioned in the first information before he enters on an investigation as to whether whose allegation do constitute a cognizable offence warranting an investigation. So, my lord, then my lord will kindly come to paragraph 54 at page number 29 of the compilation. The above question have been examined by the courts on several occasions, and they have by judicial pronouncements carved out an area, limited though it be, within which the legality of the exercise of the powers by the police officer in the realm of investigation can yet be subjected to judicial reviewability and scrutiny, and immunity enjoyed by the police officer is only a conditional immunity. The Privy Council in Nazir Ahmed's case, though, has ruled that it is of utmost importance that judiciary should not interfere with the police in matters which are within their province, has provided an exception to that above observation to the effect that if no cognizable offence or no case of any kind is disclosed, the police would have no authority to undertake the investigation. So, my lord, the Honorable Supreme Court in Bhajanlal has clearly delineated the legal principles which should guide the investigating officer when it undertakes to investigate a cognizable offence. That is, the allegation taken, disclosed in the affair, taking in its face value, whether it discloses the offence alleged. If it does not, then, my lord, if in spite of that, if the police or the investigating officer proceeds with the investigation, then those can be subject of judicial review either under section 482 of the code or, my lord, under section 226 of the Constitution of India. Now, eventually, my lord, at paragraph 102, which all are the grounds under which paragraph 102 at page 44, at page 378 for you. In the backdrop of the interpretation of various relevant provisions of the code under chapter 14 and of the principles of law enunciated by this court in a series of decisions relating to exercise of extraordinary power under article 226 or the inherent powers under section 482 of the code, which we have extracted and reproduced above, we are following we give the following categories of cases by way of an illustration, wherein such power could be exercised either to prevent abuse of the process of any court or otherwise secure the ends of justice, though it may not be possible to lay down any precise, clearly defined and sufficiently channelized and inflexible guidelines or rigid formula, and to give an exhaustive list of myriad kinds of cases wherein such power should be exercised. Lord, I will have your Lordship's kind attention to subparagraph 1, 3, 5 and 7 for the purpose of the present case. Where the allegations made in the first information report or the complaint, even if they are taken at their face value and accepted in their entirety, do not prima facie constitute any offence or make out a case against the accused. Where the where the uncontroverted allegation made in the FIR or complaint and the evidence collected in support of the same do not disclose the commission of any offence and make out a case against the accused. And then, my lord, of course, to where the allegations in the first information report and other materials, if any, accompanying the FIR do not disclose a cognizable offence, justifying an investigation by a police officer under section 156(1) of the code, except under an order of magistrate within the purview of section 155(2) of the code. Then my lord will kindly have subparagraph 5, where the allegations made in the FIR or the complaint are so absurd and inherently improbable, on the basis of which no prudent person can ever reach a just conclusion that there is sufficient ground for proceeding against the accused. Then 7, where the criminal proceeding is manifestly attended with malafides and or where the proceeding is so maliciously instituted with an ulterior motive or for wreaking vengeance on the accused and with a view to spite him due to private and personal grudge. So, my lord, this is an authority.
Number 7 is quite difficult.
My lord.
The number 7, subparagraph
Yes.
7,
Yes.
is something very difficult to establish.
There has to be some connecting factors.
Of course, you have cited those things where you say that there be steep opposition.
Yes.
And the
and basically for that 7.
But then it has to be drawn out from reading the FIR.
Yes, correct.
But then so far as your 5, subparagraph 5 is concerned,
yes,
in view of what you have pointed out,
yes, my lord,
that becomes basically, it seems to this court as of now, the strongest point in your case.
Yes, I am deeply obliged, my lord. Yes. And my lord, 2 also regarding that power of investigation. Yes. Now, my lord, we have prepared a written argument, my lord. Sorry, can you please give it? My lord, relying upon the decision of the Honorable Supreme Court, my lord, in the case of Rajiv Thapar versus Madan Lal, where the Supreme Court, my lord, has basically tried to lay down the approach of the court, my lord, as under when there is a challenge to any pending investigation, what is the approach court should adopt. So I would like to respectfully rely upon that judgment. Before that, Lordship will kindly permit me to read 3 paragraphs from this, my lord. Yes. Please come to page 2 of this written argument, my lord.
Yes.
That with respect, it is submitted that in connection with the issues of quashing, 2 further issues of law have been evolved over the time. My lord, apart from Bhajan Lal, my lord, this is what has been highlighted in Ravi Thapar's case. Firstly, the extent to which documents produced by the accused for the purpose of quashing can be seen at the stage of quashing and the steps involved in the process. Secondly, the approach to be adopted in the event accused approaches the court on the ground that the proceedings are manifestly frivolous or vexatious or instituted with the ulterior motive of wreaking vengeance. 3.1. That as far as the first issue, the extent to which the document produced by the accused for the purpose of quashing can be examined and the steps involved in the process is concerned, the Honorable Apex Court in Rajiv Thapar and others versus Madan Lal Kapoor has delineated the process as under. So paragraph 30 of Rajiv Thapar, we have quoted Miller. Based on the factors canvassed in the foregoing paragraphs, we would delineate the following steps to determine the veracity of a prayer for quashment raised by an accused by invoking the power vested in the High Court under Section 482 CRPC. Step 1. Whether materials relied upon by the accused is sound, reasonable, indubitable, that is, material is of sterling and impeccable quality. Step 2. Whether the materials relied upon by the accused would rule out assertion contained in the charges leveled against the accused, that is, the material which is sufficient to reject and overrule the factual assertion contained in the complaint. The material in such a case, the material is such as would persuade a reasonable person to dismiss and condemn the factual basis of the accusation as false. 3. Whether the material relied upon by the accused has not been refuted by the prosecution complaint, or the material is such that it cannot be justifiably refuted by the prosecution/complainant. Whether proceeding with the trial would result in an abuse of the process of the court and would not serve the ends of justice. If the answer to all these steps is in the affirmative, the judicial conscience of the High Court should persuade it to quash such criminal proceeding in exercise of power vested in it under Section 482 of the CRPC. Such exercise of power, besides doing justice to the accused, would save precious court time which would otherwise be vested in holding such a trial, especially when it is clear that the same would not conclude in conviction of the accused. So far as the second issue, that is, in the event accused approaches the court on the ground that the proceedings are manifestly frivolous or vexatious or instituted with ulterior motive of wreaking vengeance, is concerned, the apex court in Mahmood Ali and others versus State of UP and others. Lord, the citation of this case is we have given in the 2023 15 SCC.
Where you have given that?
They are given, Lord. In the compilation, serial number 3 is the judgment.
But it is not mentioned here in this your written
Yes,
argument.
yes. In the compilation, it is there, Lord.
No, in this.
Yes, it is not written, Lord. That citation is not there, yes. No, in the footnote it is there, Lord. At page number, very first page, Lord, at the footnote 4, on the first page of the compilation, 4, Mahmood Ali. It is 2023 SCC online SC 49950 is equivalent to, my lord, 2023 15 SCC 480. Para 13. SCC 488.
Okay. We'll come back after lunch.
Diploma. May it please your lordships. My lord, before the recess, I was referring to the approach to be adopted in, how to go about with the documents. Now, this judgment in Rajiv Thapar, my lord, deals with how the documents produced by the accused for the purpose of quashing can be gone into by the Honorable Court at the stage of quashing. So, my lord, second stage involved is what is the approach which court should adopt, which in my humble submission has huge bearing in this case, my lord. Therefore, if your lordships will kindly come to para 3.2 of the written submission, my lord. Yes. First step was regarding how the materials will be looked into, what weightage has to be given, etc. Now, how to go about regarding the second part. So far as the second issue, that is, in the event accused approaches the court on the ground that the proceedings are manifestly frivolous or vexatious or instituted with ulterior motive of wreaking vengeance is concerned, the Honorable Apex Court in Mahmood Ali and others versus State of UP has laid down the following principles. If your lordships will kindly permit me, my lord, I have made the judgment ready, my lord. Please give it. Actually, it is there in the compilation, my lord. For the benefit of my learned friend, my lord, I am referring to this copy. Please come to para 13, my lord.
Yes, please.
Para 13. At this stage, lordships got it, my lord. At this stage, we would like to observe something important.
Yes.
At this stage, we would like to observe something important. Whenever an accused comes before the court invoking either the inherent power under section 482 of the code or extraordinary jurisdiction under article 226 of the constitution to get the FIR or criminal proceeding quashed, essentially on the ground that such proceedings are manifestly frivolous or vexatious or instituted with ulterior motive for wreaking vengeance, then in such circumstances, the court owes a duty to look into the affair with care and a little more closely. We say so because once the complainant decides to proceed against the accused with an ulterior motive for wreaking personal vengeance, etc., then he would ensure that the FIR complaint is very well drafted with all the necessary pleadings. The complainant would ensure that averments made in the FIR complaint are such that they disclose the necessary ingredient to constitute the alleged offence. Therefore, it will not be just enough for the court to look into the averments made in the FIR complaint alone for the purpose of ascertaining whether necessary ingredients to constitute the alleged offence are disclosed or not. In frivolous or vexatious proceeding, the court owes a duty to look into many other attending circumstances emerging from the record of the case over and above the averments, and if needed be, with due care and circumspection, try to read in between the lines. The court, while exercising its jurisdiction under section 482 of the CRPC or article 226 of the Constitution, need not restrict itself only to the stage of a case, but is empowered to take into account the overall circumstances leading to the initiation registration of the case as well as the materials collected in the course of investigation. Take for instance the case on hand, multiple, anyway, my lord, it was the facts of this case. So, my lord, my humble submission is, now a conscious litigant, my lord, he might engage a lawyer to draft a complaint where he will ensure that the ingredients required to constitute the offence is there. So therefore, my lord, Honorable Supreme Court says, in such a situation, the duty of the court is not only to look into the averments made in the complaint, but also to look into the attending facts and circumstances. In which case, my lord, then the actual picture would emerge. So in my humble submission, my lord, now my lord, having regard to this, please come to my lord our averments at page 11 of the petition. Page 11, paragraph B. Because a bare perusal of the contents of the affair on the face of it, no offence and or cognizable offence is made out. The criminal proceedings are initiated mala fide, malice or for wreaking vengeance or to cause harm to the reputation of the petitioner, with ulterior objective of thwarting the operating of the petitioners, so and consequently the marketing and sale of other state lotteries within the state of Meghalaya. It is submitted that a perusal of the allegations contained in the affair reveals same to be absurd and inherently improbable. Thus, the criminal proceeding in the present case are a clear abuse of the process of law. Now, this last sentence is important, my lord. The said proceeding has been set in motion for business and commercial reason to capture market by Meghalaya lotteries and to oust other state lotteries. Incidentally, my lord, the petitioner is also a distributor of Nagaland and Sikkim lotteries, apart from, my lord, Meghalaya lotteries. I am not a distributor, but I have also permission to sell. No, Meghalaya. Not Meghalaya, other states. Nagaland and Sikkim. Within Meghalaya. And permission has also been given by the state of Meghalaya, which your lordships will find. जो हमको परमिशन दिया है नेक्स्ट स्टेट में यस नहीं हम लोग का परमिशन था ना यस हाँ if your lordships would kindly come to page 121 my lord. Yes. 121 is the order by which the order was communicated. The effective order is at page 122. To the Director, Nagaland State Lotteries, Kohima, I am directed to forward herewith the above referred letter received from Government of Meghalaya regarding marketing of Nagaland State Lotteries in the state of Meghalaya for your kind information and for further necessary action. So, my lord, I am permitted to sell the state lotteries of Nagaland. And my lord, we are paying GSTs, and which your lordships will get at.
That is not in dispute, I don't think.
Yes, yes. No, my lord, what I was trying to show, my lord, that this affair has been lost at the instance of our business rivals. Because now when I come to each of the points that I will delineate, my lord. So now on this present line of cases, my lord, I will rely upon one more judgment. My lord, why quashing assumes importance? Please come to para 8, my lord. This was disposed of on 29/11/24. Now, my lord will kindly come to para 8. It is true that appellants can apply for discharge. However, the scope of application for discharge is completely different from the scope of a petition for quashing the criminal proceeding. While arguing a case for discharge, the appellant will not be in a position to rely upon document which is not part of the charge sheet. The ground of abuse of process will not be available while arguing discharge application. However, in a petition for quashing either under section 482 of the Code of Criminal Procedure or under Article 226 of the Constitution of India, a wider challenge is available, including a challenge on the ground of abuse of the process of law. In such proceeding, the accused can rely upon documents which are not part of the charge sheet. Therefore, we reject the submission made by the learned counsel appearing for the state. Those submissions made on behalf of the state have no basis. We have dealt with the same elaborately to ensure that the same are not urged in a similar case. So, my Lord, Honorable Supreme Court has drawn a distinction between arguing an application for the charge and in the scope of a petition for quashing under 482 and or under Article 226, especially when abuse of the process of law, etc., are being pressed into service. Now, my Lord, let me deal with each of the offences and to point out to your Lordships that none of the ingredients are present. If your Lordships would kindly take the written submission, my Lord, there itself we have given it. Please come to 4.1, my Lord. Section 406 IPC. The basic and first ingredient of criminal breach of trust is entrustment. In the affair, there are no allegations as to any entrustment by any person of any property to the accused person. Therefore, the ingredient of Section 406 IPC are not made out. In this connection, reliance is placed on para 31 of the judgment of the Indian Oil Corporation and para 13 of the judgment in so and so. My Lord, if your Lordship kindly permits me, I can indicate, my Lord, from the compilation where we have annexed these parts, my Lord. As far as, my Lord, para 31 of Indian Oil Corporation is serial number 2, my Lord, page 58 to 71, 58 to 81, and relevant is at, my Lord, page number 73 and 78. And as far as, my Lord, Vijay Sarthi is concerned, my Lord, that is serial number 6 of the compilation on the scope and on the section 405, my Lord, para page 130 through 43, and the relevant is at page 138. In any case, my Lord, a plain reading of the affair does not reveal any case of any entrustment, much less anybody, my Lord, misusing it for his personal use. Then 4.2, my Lord, section 420 IPC, cheating and dishonestly inducing delivery of property. To constitute an offence under section 420 of the IPC, the complainant must show that the accused has committed an offence of cheating under section 415. The ingredients to constitute an offence of cheating as explained in in RK so-and-so versus and another versus Sudha. There should be a fraudulent or dishonestment inducement of a person by deceiving him. The person so induced should be intentionally induced to deliver any property to any person or consent to that person shall remain any property. The person so induced should be intentionally induced to do or to omit to do anything which he would not do or omit if he was not so deceived. The ingredients considered offence of 420 are so and so. So we have tried to explain, my Lord, and to show that these are not present. Then, my Lord, section 426 IPC mischief, my Lord, normally it is used in the context of some physical harm. It's not a case where any physical harm has been, either allegation is there or, therefore, my Lord, the question of invoking 426 does not arise. There we are relying on one judgment, my Lord. That is serial number 7, King Emperor versus Motilal and another. It's of course a judgment of the Allahabad High Court, my Lord, on section 426 at 425. 145, I'm sorry. 145. My Lord, it's a whole page is a paragraph, but I will only have your Lordship's kind attention to approximately somewhere in the middle portion. This sentence starting with, it is quite manifest.
Yes, please.
It is quite manifest that section 426 can have no application to the state of facts. It deals only with physical injury from a physical cause. So therefore, my lord, there is no question of, registering an FIR under 426 in the facts of this case. Then, my lord, the FIR is also registered under section 500, my lord. It's a settled proposition of law, my lord. Based on an FIR, a case under 500 or 499 cannot be instituted, my lord. It has to be by way of an complaint only. In Subramaniam Swami's case, my lord, this point has been dealt with, my lord. Serial number 8 of the compilation, my lord. If your lordship would kindly come to page 275. Please come to para 207, my lord. Another aspect required to be addressed pertains to the issue of summons. Section 199 CRPC envisages filing of a complaint in court. In case of criminal defamation, neither can any FIR be filed nor can any direction be issued under section 156(3) CRPC. The offence has its own gravity and hence responsibility of the magistrate is more. In a way, it is immense at the time of issue of the process. Issue of process as has been held in so and so, so and so, so and so. So based on an FIR, my lord, it is inconceivable to think that, my lord, and case would be registered. Then, my lord, comes the section of 1506, which is maybe while hearing the matter on earlier occasion, lordship was of the view.
That part, where is the allegation of defamation in the FIR?
There's none. Now, my lord, regarding 506. To constitute an offence under section 506 of IPC, the alleged threat must be with intention to cause alarm. This is very important, my lord. To the complainant to cause that person to do or omit to do any work. Mere expression of any words without any intention to cause alarm would not be sufficient to bring in the application of this section. But material has to be placed on record to show that the intention is to cause alarm to the complainant. In this connection, reliance is placed on Manik Taneja, Madhusri Datta, etc. I'll come to this, my lord. In the FIR, no particulars are given as to the persons threatened or coerced, the place or time of occurrence, the precise words used, or the nature of words used. In the absence of such details, it is impossible to allege commission of any offence under section 506 IPC. In this connection with the above, it is further submitted that where the FIR does not disclose the commission of an offence without anything being added or subtracted therefrom from the FIR, the same would be liable to be quashed further. For being vague, reliance is placed in para 9 and 12 of KIM. KIM is, my lord, serial number 4, my lord. Now, paragraph 9 we have quoted, my lord, para 9 and 12. In state of AP versus so-and-so, this court again held that and when an FIR did not disclose the commission of an offence without anything being added or subtracted from the recital thereof, the said FIR could be quashed. On judging the case on hand with reference to the allegations extracted herein before, in the light of the discussions referred supra, we have absolutely no hesitation to hold. The High Court clearly erred in refusing to exercise extraordinary power under Article 226 of the Constitution of India to quash the FIR dated so and so. Now, in this case, my lord, as I have already pointed out, the alleged occurrence took place on 28/3. The distributors were appointed on 31/8 and 16/9, and the draws commenced on 38/23. So, on the date of alleged occurrence, my lord, there were no stockists to be criminally intimidated. I don't think anything further is required for this matter. This is my humble submission on this point. On 28/3, there was nobody. So, my lord, these are all afterthought. So, it is in this context, my lord, lordship will kindly have due regard to the judgment in Milord Muhammad Ali's case at para 13, where Supreme Court says that court has a duty to go beyond Milord the conventional way of thinking that whether it makes out a case or not. Beyond that also lordships can venture and find out the true import, wherefrom lordships can draw. And end of the day, my lord, it has to be a lordship's satisfaction. For example, my lord, in Motilal Padampa's case, when it is a case of promissory estoppel, my lord, as to when state can resile from its promise so as to relieve the state, Supreme Court said no, it can't be the satisfaction of the executive. It has to be satisfaction of the judge. It has to be satisfaction of the court. So that is why, my lord, I think in Muhammad Ali's case, the Honorable Supreme Court says these are the approach which now we should adopt. All along we are confining ourselves to Bhajan Lal, 127, 102. Now, my lord, these have come to be added. Therefore, my lord, in my humble submission, taking note of the preponderance of the judicial view and the vague allegations in the FIR, the present is a complaint, my lord, or an FIR. This is absolutely, my lord, nothing but an abuse of the process of law. And your lordships will not permit this to continue, my lord. And taking advantage of this, my lord, many things can be done. Nowadays, that, my lord, other aspects are also there. This, my lord, money laundering, etc. Because this figure of 1500 crore is very lucrative, my lord. And in actual practice, we have seen where this 1500 crore stands vis-a-vis, my lord, actual state of affairs, which is not even 38 lakhs, 37 lakhs and not.
Now, can your assessment be disputed?
My lord?
The assessment which you have given in your petition,
yes,
about the 37 lakh,
yes,
that is your own calculation, isn't it?
It is our own calculation, but based on the, my lord, arithmetic.
So it cannot be disputed, you say?
Yes, in my humble submission, perhaps it cannot be disputed, my lord. And they haven't filed any affidavit also in any case. And total turnover for the entire period would be, my lord, 57.19 crore. Yes, 57.19. It's para 24. My lord, at page 25, we have clearly said, it will be, my lord, no, 51 crore 99 lakhs. Because 51 lakh 99,376 tickets were involved into 10. Yes, this is the total. And total turnover we have indicated, my lord, including everything, it will be 67 lakhs 59,000 18,080.
And what is the amount mentioned in the FIR?
1500 crore.
1500?
100 crore. In fact, my lord, I'm not pleading anything. Our client, my lord, he had suffered an attack after this, after hearing all this. He has suffered an attack. And in fact, he is under treatment. So these are aspects, my lord. Therefore, my lord, my humble submission in this case is, there is absolutely nothing, my lord. There cannot be any question of criminal intimidation because on 28/3/22 there was nothing. No stockist, no nothing. It's not the case of any stockist that they have been, my lord, criminally intimidated by anybody. It is the director filing an FIR, my lord. I do not know what is the basis of filing FIR. There is no allegation who has been threatened. There are vague allegations. My lord, on 506, I'll just place two decisions and then I'll wind up, my lord. On 506, my lord, if your lordships would kindly have Manik Taneja at page number, my lord, 278. If your lordships would kindly come to page 282.
Yes.
My lord, at page 282, towards the bottom, para 11, section 506 is quoted, 503. Then please skip over the page, my lord, at page 283, para 12.
Yes.
In the instant case, the allegation is that the appellants have abused the complainant and obstructed the second respondent from discharging his public duties and spoiled the integrity of the second respondent. It is the intention of the accused that has to be considered in deciding as to whether what is stated comes within the meaning of criminal intimidation. The threat must be with intention to cause alarm to the complainant, to cause that person to do or omit to do any work. Mere expression of any words without any intention to cause alarm would not be sufficient to bring in the application of this section. But material has to be placed on record to show that intention is to cause alarm to the complainant. From the facts and circumstances of the case, it appears that there was no intention on the part of the appellant to cause alarm in the mind of the second respondent, causing obstruction in discharge of his duties. As far as the comments posted on the Facebook are concerned, it appears it is a public forum meant for helping public. An act of the appellants posting a comment on the Facebook may not attract ingredient of criminal intimidation, that is section 503. Then my lord will kindly have Madhusri Datta, my lord, serial number 10. Please come.
How do you decide what would cause alarm? I may get alarmed by certain things, you may not.
No, it will depend upon the intensity, my lord. At least, my lord, there must be something in the complaint to indicate. Otherwise, my lord, it will be too open-ended. And Lordship will kindly also see the attending facts and circumstances.
Definitely.
Absolutely, Lordship is correct. Therefore, my lord, that's why it is always said, my lord, when it comes to exercising power under either 482 or 226, court will use that power sparingly. The reason being, this power is a special power. So, it is meant for cases like this, in my humble submission, subject to what your lordships may say. Then, my lord will kindly come to this Madhusri Datta's case, my lord, at page 292. Para 34 towards the bottom of 292. This court had the occasion to examine the ingredient. I'm sorry,
Yes, sir.
page 292.
Yes, sir.
Page 34, para 34. This court had the occasion to examine the ingredients of section 503 and 506 of the IPC in Manik Taneja, where it was observed as follows. A reading of definition of criminal intimidation would indicate that there must be an act of threatening to another person, of causing an injury to the person, reputation or property of the person threatened, or to the person in whom the threatened person is interested, and threat must be with the intent to cause alarm to the person threatened, or it must be to do any act which is not legally bound to do, or omit to do an act which is legally entitled to do. In the present case, the complaint does not specifically attribute any threat or intimidation to the second accused. Therefore, ingredient of section 506 of IPC are not made out against him. The argument that the accused has acted at the behest of the second accused is untenable, as section 34 of the IPC, which imposes vicarious liability in criminal matters, has not been applied in this case. However, the complaint has stated in her complaint that she was threatened by the first accused as detailed below. Before an offence of criminal intimidation to be made out against the first accused, it must be established that she had the intention to cause alarm to the complainant. A review of the alleged threat reveals that complainant is primarily alleging illegal termination, which constitutes a civil dispute rather than a criminal intimidation. It is also appellant's case, which has not been disputed by the complainant, that complainant has filed a reference before the Labour Court challenging her termination and seeking reinstatement along with back wages. Given these circumstances and materials on the record, the ingredient of section 506 IPC are not disclosed against the first accused. So, my lord, the materials there must be an intention, then it must, specific allegation must be said, my lord, that he has been prevented from doing this, or he is legally bound to do this, or he has been prevented. Vague allegations, my lord, that too on a background where it exists none, because on 28/3/22 the stockists were not even there. Finally, one judgment, my lord. Lalit Chaturvedi versus State of Uttar Pradesh is a very recent case, my lord. Paragraph 7. My lord, page 7, sorry. Please come to the last 3 sentences of page 7, my lord. The sentence starting with the charge sheet. The charge sheet does not refer to section, I'm sorry, my lord, page 7 towards the bottom, last 3 sentence. The charge sheet,
Just a minute. There is.
I'm sorry,
Appears there is no page 7 here.
on top, lordship will get the page.
Page 7. There is 6. Then it comes 9.
Oh.
Then 8. Then 7 is the last page.
Yeah.
Well, clipping you have not done it properly.
Mala, I'll correct it, Miller. Kindly give me.
Take this.
Nah. Page 7, my lord.
Yes.
The charge sheet does refer to section 506 of IPC, relying upon the averments in the complaint. However, no details and particulars are given when and on which date, place the threats were given. Without the said details and particulars, it is apparent to us that these allegations of threat, etc., have been made only with an intent to activate police machinery for recovery of money. So, my lord, bereft of these details, one cannot countenance a situation of invoking 506. Therefore, my lord, taking in totality of the facts and the legal principles governing, my lord, exercise of power under 482, my lord, my humble submission is, it's a fit case where your lordships will quash the proceeding because, my lord, it's an abuse of the process of law. That's my humble submission. My lord, once again I apologize, my lord, for what had happened, my lord.
It's all right. It had happened repeatedly. That is.
No, I know. I'm sorry. Actually, what had happened, my lord, this morning also I tried to correct it. Nowadays, what had happened, my lord, because of this AI is intervening, now it's overrides the, my lord, the other mandate.
Same submission I will direct it for same FIR, same.
So one judgment to do for.
Yes.
Yes. Use an associate.
Mr. Mohanto is item
17.
Item 17. Yes.
May it please your lordship. Lordship, my friends, they have bombarded the state. So many judgment, Lord.
Yes.
May it please your lordship. Lordship, the case, the matter, your lordship, the affair is at the initial stage of the investigation, your lordship. Whether ingredients or no ingredients, in my humble and respectful submission, lordship, this is not the stage.
What about the proposition of law? What has been shown
lordship,
to this court?
I would carefully, your lordship, cite paragraph 103 of the Bhajalan case. Yes. Lordship, kindly come to page para 103. Kindly see, your lordship, there.
Yes, please read up.
The observation made by the Honorable Supreme Court, your lordship, that the power of quashing, your lordship, should be used sparingly, your lordship.
That has been
lordship, that is. Lordship, kindly see. We also keep note of question to the effect that the power of quashing a criminal proceeding should be exercised very sparingly and with circumspection, and that too in the rarest of rare cases, that the court will not be justified in embarking upon an inquiry as to the reliability or genuineness or otherwise of the allegation made in the FIR. So this is an observation, Your Lordship. Whether Your Lordship would embark that the allegation made in the FIR are not true, not correct, false. No, Lordship, in my humble submission, Your Lordship, this is not there. Lordship, the FIR, Your Lordship, paragraph 8 and 9, Lordship, kindly come to the FIR at page 135, Your Lordship. Paragraph 8 and 9, Lordship, at page 142 and 143.
Yes.
Lordship, kindly see. This being so, the office of this Directorate of Meghalaya State Lottery has really learned that one so and so, so and so and so, so and so, so and so, conspiring together and indulging in the illegal activities of criminally intimidating, threatening, coercing, and causing undue influence on the stockists and sub-stockists and others. In order to, may I pause here, Your Lordship? These stockists and sub-stockists, these are the people to be called, Your Lordship. Allow the investigation, they will be called, Your Lordship. In order to in order to destroy the competition, since the named person are practicing monopoly in the field of lottery business, the criminal activity of the above person caused loss to the exchequer of the state government of Meghalaya. The person referred to above have been unlawfully preventing the official distribution and business of the Meghalaya state lotteries continuously through various illegal means of criminally threatening the stockists and others, and also by manipulating them with false and defamatory information to curtail the distribution of the Meghalaya state lottery at places by the Shillong and other parts of Meghalaya and other states, West Bengal, Punjab, etc. It is pertinent here to mention that the so and so through their so and so henchmen and gangsters keep continuous and serious threat to the stockists, sub-stockists, and thereby prevented them from carrying out the business with the Meghalaya State Lottery. The said illegal activities carried out by Mr. So and so through their antisocial elements cause huge business loss to the Meghalaya State Lottery, approximately to the tune of rupees so and so by indulging in the criminal activities of threat, coercion, Your Lordship. Lordship, can you see the allegation, Your Lordship? There is a loss, Your Lordship. The figure of 115 crores may not be correct, or it may be correct, Your Lordship, depending on the investigation, Lordship. Lordship, that there is a loss caused to the state, Your Lordship, that is supported, Your Lordship, by the statement made in paragraph 25, Your Lordship. Kindly come again, Your Lordship. It has been referred, Your Lordship. Paragraph 25, Your Lordship, para 7. So there is a loss. The admitted fact that there is a loss, Your Lordship, of 37 lakhs. The money may not be big, Lordship. The fact remains that there is a loss.
That is not an admitted fact. There is an assessment given by them. What could be maximum?
There is a loss. There is a loss.
It doesn't amount to admission. It is not an admission.
Lordship, kindly see. We say, Lordship, the FIR say that 1,500 crores, Lordship.
So far,
they say, no. It is not a loss of 1,500 crores. It is only a loss of 37 or 30 lakhs, Lordship.
They say at the best.
Whether this figure is correct or not, loss, Lordship, that is for the investor to see, Your Lordship, whether there is a loss or not, Your Lordship. Because now we are only at the stage of the FIR, Your Lordship, where the investigation of the case is yet to commence or yet to take shape, Your Lordship.
Yes.
Lordship, it is on this basis, Your Lordship. It is on this basis of the basis of this allegation that the FIR has been registered, Your Lordship, and the investigation is yet to commence, Your Lordship. Lordship, my humble.
Investigation is yet to commence.
Lordship, yes, Lordship, yes.
See, it means like this FIR is basically it's lying in cold storage.
It's
11/9/2023.
Lordship, because this
this
it came to Lordship, kindly see the information was
11/9/2023.
Lordship, yes, the information was
And you say investigation is yet to begin.
made, Your Lordship, in sometime in the month of September 2023, Your Lordship.
So that will go on. Your submission will go on.
No, information is received only in the year 2023, Your Lordship. And we are in the initial stage of the investigation, Your Lordship. And we are
just now you said investigation is yet to begin.
Yes, initial stage, Your Lordship, is common in it because there was an interim.
Whether it is yet to begin or it is.
It has already begun, Your Lordship. We have to call people, Your Lordship. We have to examine a number of people, Your Lordship.
What is the stage of investigation? How many you have called right now? Till now, till today?
Let me just
Please, tell us. Please, tell your officer to come near you or you go to him and then see.
Lordship, according to him, Your Lordship, the registration of the FIR and the initial investigation was done by the Shillong Central Police Station. Thereafter, Your Lordship, it was handed over to the state CID, Your Lordship. So now the state CID, Your Lordship, is
when it was handed over to state CID?
24.
In the year 24, Your Lordship.
Which month?
I received on November only, sir. Before that, it was on August.
And what is the stage of investigation now?
After that, we planning to call all the distributors and all, and we asked for the documents from the complainant. She delayed to submit the same, and later on this last month only she submitted all the documents. At that time already it was state order.
So you are at the stage of seeking details from the complainant.
Right, sir.
And we could not go ahead, Your Lordship, because there is a restraining order.
It's passed only recently, Mr. Sulai.
On 19.
No,
At least look at the. You see,
what happened, Your Lordship? That was made before, Your Lordship, and those documents were handed over subsequently.
Right, sir.
Subsequently, Your Lordship. So we cannot do anything, Your Lordship, because the
matter was handed over to CID only in November 2024.
24, Your Lordship, yes.
Yes. You can tell your officer to go. Yes.
So, Your Lordship, yes. It was handed to the CID, Your Lordship. The investigation now will start, Your Lordship. Or at least allow the investigation to go on, Your Lordship, because, Your Lordship, if there is no case, Your Lordship, suddenly, Your Lordship, the matter will end in the closure report. It is not a case of abuse of. It is not a case of malicious prosecution, Your Lordship. The fact remains, Your Lordship, as revealed in the FIR, Your Lordship, that there was a threat. There was a threat. There was a loss, Your Lordship, to the state.
And when was the threat made?
Lordship, as I have submitted,
The
Your
person who received the threat, he doesn't know when he received the threat.
Lordship, there is an allegation.
Lordship,
there is an allegation, Your Lordship, in the FIR that they were threatened, Your Lord. They were threatened, Your Lordship. When and where, Lordship, that is for the investigation to reveal, Your Lordship.
And then what else you want to say? Any other points?
Lordship, only my humble and respectful submission. Allow the investigation, Your Lordship. If there is nothing, we will place the closure report before the appropriate court, Your Lordship. That is my submission, Your Lordship.
Deeply.
He has not disputed a date of occurrence, so that should be good enough for you. All right. Thank you.
Deeply obliged.
We'll keep it reserved because there are some other matters.
Lordship.
Hearing judgment.
Obliged.